So, dear colleague, allow me to introduce Ákos Tussay from the Pázmány Péter Catholic University, and he is our next lecturer about political justice and natural law, some preliminary thoughts on Aristotle's thoughts. So, the floor is yours.
Thank you. Thank you very much, and thanks for having me here. I'd like to hand out some handouts. So, will you be so kind as to pass up the wires? Thank you. The handouts were prepared in a haste, and I just realized that it's incorrect in terms of the chapter. So it's from book 5, chapter 7 of the Nicomachean Ethics, whereas the paper indicates it's chapter 6. Sorry about this mistake. As Adam has said, I'm going to talk about political justice and natural law in Aristotle's Nicomachean Ethics, based on the 5th book of the Nicomachean Ethics. And I'm going to offer some preliminary thoughts. This is basically a critical literature review, so there's much debate on how to read Aristotle's Ethics in the book 5, which is chapter 6 and chapter 7 about political justice, because there's some indication that there is a room for a natural law reading. So let's proceed. In this presentation, I try to offer some preliminary insights to the interpretation of the 5th book of Aristotle's Nicomachean Ethics, which constitutes Aristotle's fullest treatment of justice, both as a disposition or interpersonal relation, which is captured by to dikaion, and as a particular virtue of character described by dikaiosyne. So there is this dichotomy between justice as an interpersonal relation and the justice as a virtue of character in the text. Aristotle considers several issues attending on the idea of justice, such as how may a just action be characterized, and whether justice, like the other virtues, could be understood in terms of proportions. Namely, is the virtuous a mean between two extremes? Are there different sorts of justice? And of course, the problem of agency. That is, whether justice and injustice are voluntary, which prepares for the crucial discussion on whether one can be unjust to oneself. Though this question may at first appear to be just accidentally related to the study of jurisprudence, central to Aristotle's discussion is a query of tremendous significance: is the artificial order of the polis entirely made of arbitrarily posited conventions, or is there a natural source of justice to the legal order as well? In other words, is it legitimate to speak of natural justice, and if so, how does it relate to law? Aristotle himself described the legal order, a product of the legislative science, which he understood to be a kind of phronesis. Hence, if Aristotle was indeed a natural law thinker, he would imagine natural law to be operating within the contingent domain of praxis. But Aristotle's potential contribution to the natural law tradition is a matter of controversy. I attempt to tackle this problem head-on after the following question. First, I intend to consider Aristotle's writing project in terms of book 5. What are the main conceptual units of this book, and what are the stumbling blocks of its interpretation? Next, I take a look at the various kinds of justice and try to accommodate political justice within Aristotle's general framework. And finally, I'm going to consider the problem of political justice with reference to the essence of conventional and natural justice. In doing so, I wish to engage both with Aristotle's original text and its different interpretive traditions in proposing a plausible method of assessment. The principal aim of this study is thus to sketch out a tenable procedure for interpreting Aristotle's idea of political justice and accommodating his potential contribution to the doctrine of natural law. So let's start by some general remarks on the 5th book of the Nicomachean Ethics. The 5th book of the Nicomachean Ethics is traditionally divided into 11 chapters, The first chapter introduces the problem of justice, and it raises three questions. What sort of action is justice concerned with? What sort of mean is justice as a virtue? And what is the just a mean of, or what are its extremes? These questions are then dealt with through the subsequent inquiry from chapter 2 to 5, which analyzes the various species of justice being united by the goal of showing how justice is a mean. Chapters 6 and 7 somewhat abruptly starts a new discussion about political justice, which has made those passages subject to editorial amendation and reorganization. Finally, from chapter 8 to 11, Aristotle is occupied with the problem of ethical agency, injustice and unjust actions, and the criticism of Plato's theory, that is, whether it is possible to be unjust to oneself. The most cogent scholarly division of the book is put forward by Thornton Lockwood, who disconnects chapter 6 and 7 from the discussion of chapter 2 to 5 and claims that chapter 6 is the introduction to the problem of ethical agency set out in chapter 8. In his opinion, Aristotle's treatment of the various species of justice is related to the initial question of justice being a mean, mesotes, and the analysis of political justice in chapter 6 initiates a new inquiry. He argues that virtuous actions presuppose deliberation, prohairesis, which in turn necessitates full ethical agency. A character state that allows virtuous action. Since slaves, children, and women were not thought to be fully ethical agents, the discussion of agency from chapter 8 should be preceded by the description of its scope, which is political justice. The conclusion is amplified by the use of dikaion, as understood in terms of a sort of justice, implying that those relations in which the agents are lacking full ethical agency do not have justice to themselves, but only something which resembles justice, dikaion. This could have political implications and could perhaps be extrapolated to Aristotle's distinction of natural and unnatural constitutions in the politics, but that is beyond the scope of the Nicomachean Ethics. So let's see the Nicomachean Ethics definition and division of justice. Aristotle maintains that according to the common opinion, justice is a disposition, a virtue of character that makes those who partake in justice the doers of just things, and it causes them to indulge in doing and wishing for justice. Unlike the sciences and capacities, characteristics do not admit opposites. Hence, if the character state of justice is unknown, it could be defined through its opposite, which is injustice. Obviously, there are two kinds of injustice. The unlawful on the one hand and the overreacher and unequal on the other hand. From this follows then that there should be two opposite states of justice as well, namely the lawful and the equal. Of these, the lawful covers justice in the broader sense, since most of the things commanded by the laws are prescribed on the basis of the whole of virtue. Particular justice is characterized by equality, as it is opposed to unequal gain, arising from the want of honor, money, and so on. That is why particular justice occurs either in the distribution of these things, like money, honor, and so on, or in the rectification of unequal gain. Though it looks as if Aristotle had proposed two kinds of particular justice, there should be, in fact, merely one virtue, particular justice of character, which displays itself especially in distribution and rectification. For Aristotle, distinction lays between the whole of justice and particular justice, but the latter is referred to as in the singular. So instead of distributive and rectificatory justice, one ought to distinguish two spheres of just action in which the single virtue of justice comes into play. Justice in character should enter in both distributive and rectificatory actions. Political justice, the subject matter of this whole inquiry, is wholly unrelated to the discussion on particular justice. And so this is an entirely new discussion in the ethics. So let's proceed with the consideration of political justice. Political justice is unqualified justice, haplos dikaion. And so Aristotle seems to have returned to his original inquiry about justice according to the whole of virtue. Now, the precondition for political justice is a proper delineation of agency. Political justice belongs only to those who are by their very nature suited for law, and whose relations are governed by law as well. What is more, there is no justice proper, only a sort of justice, the dikaion, in non-political relations, from which follows that there is no rule of justice independent of law. And this consideration must be a crucial criterion in assessing Aristotle's subsequent analysis. Unfortunately, Aristotle's rather brief account of political justice is very controversial and open to contradictory interpretations. That is why I think it is necessary to identify those issues on which a proper rendering of Aristotle's interpretation may hinge. So let's proceed with the handout part. Let's tackle those interpretive dilemmas. Obviously, the first such interpretive issue concerns the relationship between natural and conventional justice. But actually, this question ought to be preceded by another inquiry, namely, what is in fact the subject of Aristotle's analysis? All commentators take it for granted that Aristotle is deliberating on actions. But in the light of his latter distinction of justice, and he uses to dikaion, not dikaiosune, justice as in virtue, and the doing of justice, which is a reaffirmation of his introduction to the problem of agency, this is rather far from being that evident. Another issue is the apparent contradiction between the claims of variability and invariability for the domain of natural justice. The precise role of the example of right-handedness, and finally, there is Aristotle's controversial insistence on the best constitution by nature. So let's start with the preliminary question of Aristotle's subject matter. Aristotle is expounding the meaning of political justice, a part of which is natural, another conventional. The neutral tomen and tode refer to dikaion, implying that political justice has a part which is natural justice, and another which is conventional justice. The subject of his inquiry is thus justice as a disposition or interpersonal relation, to dikaion. In this respect, Aristotle is thoroughly consistent. He only starts discussing justice and injustice in action when he introduces the problem of agency at the very end of the chapter. Now, throughout the fifth book of the Nicomachean Ethics, to dikaion should be rendered as a relationship or disposition between distinct persons and with respect to some value judgments, based on which there is room for distribution or rectification. So there exists a relationship governed by law between them. For justice is the outcome of a just action, something which should be aimed at by anyone possessing the virtue of justice in action. As such, it is fundamentally wrong, I think, to see Aristotle as deliberating on justice in action, and to view his examples of ransom and sacrifice in terms of normative ethics. As early as Aquinas' commentary on Aristotle's Nicomachean Ethics, Aristotle is being associated with a theory of natural law, operating on the basis of unchanging and rationally discernible moral precepts. And Aquinas supports his reading through demonstrating that Aristotle's examples of ransom and sacrifice contain an element of invariable truth. Prisoners ought to be ransomed or that divine honors may be given, which are commixed with variable positive rules that determine the particulars of the just action. But Aristotle's ethics revolves around justice as a virtue without much concern as to moral precepts. This fallacy has dire consequences to the second issue, the translation of the mean and the particles. Since the Greek text allows two plausible translations, namely that the natural and conventional parts of political justice are either separated from one another, or they ought to be discernible yet without essential opposition, the text could be rendered to imply both that there are two distinct sources for law, or that there are two distinct domains which are nonetheless united in political justice. Apart from a minority view, Aristotle's modern commentators tend to adopt some version of the latter option, which is often referred to as the so-called horizontal interpretation. They all argue for some more or less fixed and unchanging principles of natural justice, which could inform the legislator with a view to the natural ends of the polis, or even to provide a normative criterion for the assessment of legislative decisions or constitutions. There is, however, an obvious problem to this interpretation. Namely, it can hardly account for Aristotle's paradoxical statement concerning the variability and invariability of natural justice. When the distinction itself is introduced, Aristotle seems to have separated natural justice from conventional precisely by virtue of its fixed and eternal nature. He was also apt to point out that all rules of justice are equally variable, the rules of natural justice being included. Given Aristotle's statement is explicating the opposition between natural and conventional justice, the one being invariable and existing irrespective of our understanding of it, the other being conventional and posited, the Greek text should be rendered as separative. That is, the domains of natural and conventional justice are mutually exclusive. Yet, contrary to the thesis of a vertical division, it does not imply that there exists any hierarchy between these two. It does follow, however, that there are two distinct sources for law. Political justice is intrinsically associated with law. Both of its parts cannot be but linked to legal formulation. The source of authority may be merely convention or nature itself. Aristotle is speaking of Thussay dikaion, in which the instrumental dative denotes the cause of association. That is to say that the rules belonging to natural justice have their source of origin in nature. And Aristotle does explain his meaning when he points out that justice is of two sorts, the lawful on the one hand and the equal on the other hand. It follows then that the domain of Thussay dikaion, natural justice, is characterized by equality, a proportion which does not change and does not depend on our understanding of it. Nevertheless, equality is not unqualified, but being dependent on judgment of worth, which results in the establishment of different constitutions with different criteria of equality. And so it is in some way subject to variance. But there are two additional questions that may challenge my reading, namely the argumentative position of the right-handedness and Aristotle's reference to the best constitution at the end of the chapter. The problem of right-handedness is treated in details by Fred Miller Jr., who proposes a theory of normative nature, encompassing that which is normal or regular in the natural world. Such a reading is closely related to the Magna Moralia's exposition, yet it could be also entertained irrespective of it, because the Magna Moralia's Aristotelian authorship is highly debatable. It could show that the principles of natural justice are capable of admitting variance, but it could also show that, like right-handedness, the domain of natural justice is variable. Since the problem of right-handedness is introduced by kai epiton alon ho autos harmosei diorismus, I think it is more plausible to assume that right-handedness serves as an example for variance, but not an example for natural justice or normative nature. It implies that right-handedness is not an exact example for the kind of discussion he has, but it is similar to the discussion he has. Finally, great stress has been laid on Aristotle's controversial insistence on the best constitution. The Greek text itself, once again, allows two translations. Aristotle could either mean that there is one constitution, which is by nature best everywhere, or that everywhere there is one constitution, which is best by nature there. Most commentators side with the first option, which sets the stage for a normative comparison of constitutions by virtue of their intrinsic merits. The majority view is challenged only by Roland Polanski and John Muller, who offer a rather compelling interpretation of Aristotle's use of pantakou everywhere. According to him, Aristotle's employment of everywhere, pantakou, betrays that he could not possibly mean one and the same, because in line with the other occurrences in the chapter, Aristotle should not be aware himself of the idiom mia kai he auti or something else of the kind. And I think his conclusion is amplified by the findings of the Politics, where we can find three natural constitutions in Aristotle's discussion without any hierarchy or hierarchical arrangement after Plato's division, for instance, in the Republic. So let us conclude. I think it can be settled with confidence that Aristotle's analysis of political justice is an elaboration on justice simpliciter. And so it is unrelated to his prior treatment of special justice in distribution or rectification. Political justice is that variety of justice which belongs only to those who are equal and whose relations are naturally governed by law. Hence, all considerations of political justice are being dependent on law itself. And it is this premise on which any sound analysis of Aristotle's potential contribution to the doctrine of natural law should be established. In that, I have identified two obstacles capable of frustrating our understanding of Aristotle. The first such obstacle is the definition of Aristotle's subject matter. What is political justice concerned with? And the second obstacle, how may Aristotle's distinction of variable custom and invariable nature may be reconciled with? I've proposed a novel reading, but in alignment with the traditional patterns. As such, I've argued that the subject matter of chapter 7 is political justice as a disposition or interpersonal relation which is regulated by law and having its authority derived either from legislative enactment or natural equality. And so Aristotle's distinction of natural and conventional justice is far from being a horizontal division. Rather, it is a separative division of two opposite sources for legal authority. This means that those relationships in which political justice may be rationalized are either established through legal enactment, like the settling of ransom or rules of sacrifice, or they are stemming from natural equality combined with a peculiar understanding of worth attending on the principle of equality. Aristotle does not provide any examples of this sort, but the classification of different constitutions could serve as such an example. Finally, as to Aristotle's potential contribution to the doctrine of natural law, I claim that based on the ethics, there is no such thing in Aristotle. The natural justice of the ethics does serve as a source for law, but only in terms of authority, without any implications to moral validity. What is more, natural justice does not have the force of law unless it is posited and being accepted by a given political community. As such, based on the ethics, Aristotle did not subscribe to any natural law position, in my opinion. Thank you very much for your kind attention.